virtual hearings room. Please remember to turn off both your camera and microphone. I will now hand over to the Chairman, Sir John Mitting, to continue proceedings. Chairman.
Thank you. Mr. Rodker's son is now going to read his witness statement. The usual video will not be played because this is being transmitted live and anyone is free to tweet or transmit what is going on at any time. Mr. Rodker.
Thank you. Good afternoon. I'm actually going to be reading just the most salient parts of Ernest's statement, so not every word. Stop me if you're losing track. That's just to save time. I will be reading, obviously, all the relevant parts. Can I just...
Forgive me for interrupting a moment. If you're not going to read the whole statement, it may be that you can complete this task by about 3:30. If you're going to do that, then we won't take a break.
I am not. I haven't sort of read it out loud, but I'm not predicting it will take more than an hour. So yes, I would hope we would be finished by 3:30.
Thank you.
I believe there's a photo document 050. If I could just show, that's a photograph of my father, Ernest, to show the inquiry to begin with. Is that there? Would I see it if it was there?
It has not yet appeared, but
I can easily.
It's coming. Here it is.
No, that's definitely not it.
You're quite right.
That's it. Okay, so that's my father, Ernest. Thanks very much. So to start the statement, my full name is Ernest Rodker. On the 20th of December 2019, I was provided with a Rule 9 request to provide evidence to the inquiry. It relates to some of my campaigning activities over a period of 30 years, from the late 60s to the late 1990s, and poses questions relating to my interaction with a number of undercover police officers, including Jim Pickford, Michael Scott, Phil Cooper, Jim Sutton, Andy Davey, and Mike Ferguson. I have been provided by the inquiry with a bundle of about 53 documents with a Rule 9 request posing 22 questions. Stop the 70 Tour campaign. I'm asked what my political activities as a member of the Stop the 70 Tour were, including my positions of responsibility and the dates held. I was active in Stop the 70 Tour throughout its existence. It started in 1969 until it was disbanded in May 1970 with the cancellation of the planned 1970 cricket tour of the UK by the white-only South African team. The campaign against sports connections with South Africa continued beyond the 1970s in other forms, and I remained involved in those campaigns. I did not have a formal position within Stop the 70 Tour as far as I recall. I was active in a much smaller group of activists, a direct action group, DAG for short, which I also described below. I am asked what were the aims of Stop the 70 Tour. Its immediate and principal aim was to stop the white-only South African cricket team from touring the UK in 1970. More broadly, its aim was to make a very strong political point that people representing apartheid were not welcome in the UK. I'm asked about its methods. We sought to impress on the South African teams the fact that as an all-white team effectively promoting the apartheid regime, they were not welcome. We wanted them to know the level of opposition there was to what they stood for, and for them to reflect on whether it was the right thing, practically and ethically, to tour the UK. We used all classic forms of non-violent direct action, NVDA. Pitch invasions were the most prominent. We understood and sought to follow the well-known principles of NVDA and civil disobedience learned from recent history, such as the struggle for Indian independence by Mahatma Gandhi and for Black civil rights by Martin Luther King. I personally had already absorbed and applied these principles as a result of my earlier involvement in the Committee of 100, which was referred to below. So for the Stop the 70 tour, it was clearly understood by anyone who came across Stop the 70 tour or participated in its demonstrations that we would only engage in peaceful campaigning. This was made known openly and explicitly, regularly at meetings. It was a common understanding for all those involved. This comment applies to all other campaigns I was involved in, such as the Direct Action Anti-Apartheid group I was involved in below and the Committee of 100 below. I am asked if Stop the 70 tour vetted its members. My comments relate principally to Stop the 70 tour, but I was also involved in a smaller group involved in direct action. I cannot now remember what name this direct action group was known by. These activities included things like going to a team hotel to carry out demonstrations there. For example, in the campaign against the white-only South African rugby team in 1969, I booked into a hotel in an affluent part of central London overnight where the team was staying. I sat among the players in the lounge, eavesdropping on them and getting their room numbers. While they were still in the lounge or having supper, I may myself have glued their door locks and certainly shared the room numbers with other campaigners who did so. Only a couple of doors were affected in this way, but I understand it had an impact on the South Africans. They were unhappy about this. I learned later from a journalist connection of Peter Hain. On other occasions, we waited outside the team's hotels for them to get on their coaches. We then got on the coaches as well and refused to leave. We had to be carried out. This both delayed the team and caused them inconvenience. It is worth underlining that we were effective in the sense that in the short term, the rugby team was, we learned, keen to stop the tour and wanted to go home as a result of our actions. In the medium term, we contributed towards the decision to abandon the 1970 cricket tour plans. And in the long term, we contributed to the isolation of apartheid South Africa from international sport, a factor in its eventual downfall. I know I am not asked about my knowledge or interaction with Mike Ferguson. I can say that I don't remember this person. I understand in any event that this is the officer's real name as opposed to his cover name, the name I might have known him by. And if I am said to have come across him, it would obviously help to know his cover name. If I were asked to comment on him, I would also be assisted by seeing a contemporaneous photograph of him and other information about what he looked like and what his involvement with me was. I'm asked about the Stop the 70 tour first national conference on the 7th of the 3rd, 1970, and a report on it dated 9th of the 3rd, 1970. Specifically, I am asked if this meeting was open to the public in the morning and private delegates only in the afternoon. I cannot remember if this was public in the morning and private in the afternoon. I am asked by reference to paragraph 8 at page 3 of the report about Stop the 70 tour's attitude to violence. I agree that we were committed to non-violent direct action. I would not accept that it was right or accurate to describe our tactics, as the report does, as, quote, militant, particularly given the connotations of that word in that era. Yes, we were committed to disrupting the apartheid South African sports teams, but it was always very clear and frequently said that our opposition to them would not include acts of personal violence towards them, for example, punching them. It involved peaceful civil disobedience. It also included relatively minor damage to property, for example, gluing door locks, but nothing more significant than that. Anyone attending any of the meetings or participating in the campaign generally would be made aware of this, and by continuing to be involved, would be understood to have committed to these principles. The common and the fundamental principle it kept to was NVDA, no violence to people and only minor proportionate damage to property. This is paragraph 47. Now, I am asked how concerned we were generally about the risk of reporting by undercover officers. There was an awareness that it would almost certainly be the case that there would be infiltrators within the movement, and that more generally, the authorities were trying to monitor what we were doing by the use of phone tapping and such like, and the placing of people covertly at meetings. Our principal concern was that the UK police were the ones monitoring and infiltrating us, and this included the possibility of there being the likes of undercover police officers in our midst. I assumed that the apartheid South African authorities and security services also had an interest in, may have monitored or infiltrated, and may even have taken action against the anti-apartheid movement. I assumed that they were particularly interested in the high-profile organisers, those who were central to the national campaign. Our overriding response to this was that none of this should deter us doing what we planned to do. And of course, some actions were planned outside the wider group to keep them secret and guard against the risk of them being known to anyone monitoring us. I am asked if I was surprised to learn that undercover officers reported on my ST activities. That's the acronym for Stop the 70 Tour. I am not surprised that they monitored my activities. This is partly because before I was involved in the campaign against apartheid, I was involved in the Committee of 100. This was a British anti-nuclear group of the 1960s. It had come to the attention not only of the media, but also of the police, the prosecutors and the courts as a result of a high-profile campaign and campaigning methods involving non-violent direct action. For example, through my involvement in the committee, I and many others in the committee, including the philosopher Bertrand Russell, had been sent to prison as a result of our campaign of non-violent direct action against US nuclear bases. This came about when a number of us were prosecuted for planning disruptive demonstrations and civil disobedience. We appeared at, I think, Bow Street Magistrates Court and were found guilty of a breach of the peace or some similar wrong. We were given the option of agreeing to be bound over to keep the peace or to go to prison for 3 months or more. Most of us chose to go to prison. I seem to remember that some of the evidence used against us included evidence from the police of covert surveillance of our plans and discussions for action. I am asked to what extent did Stop the 70 Tour break the law in order to further its aims? I am asked this question in the context of a report on a meeting of the London Region Conference of Stop the 70 Tour, a meeting I am said to have chaired on the 5th of April 1970 in St Pancras, London. Which mentions the possibility of conspiracy charges. The Direct Action Group, I've just dropped down to paragraph 55, the Direct Action Group was about planning actions rather than for organising public events or publicity in the conventional sense. Certainly Direct Action Group could not be described as delegates to the Stop the 70 Tour in the way the planning committee was apparently seen in this report. But yes, we were aware that conspiracy or other criminal offences might be used against us. I have no legal training, but I understand that at this time, the now discredited conspiracy charge could be used to prosecute as a criminal offence the planning of what might otherwise amount to civil wrongs, such as trespass. And further, in those days, the use of conspiracy charges took on a political aspect. We were involved in civil disobedience. We were putting our bodies in the way of apartheid South African tourists. We were not planting bombs. We were not even carrying out wanton acts like going into South African rooms and trashing belongings. We were doing nothing on the scale of what the South African state regime was doing to its majority black citizenship under apartheid, systematically and repeatedly under cover of the law. And I note that to paragraph 11 of page 3 of this report, it is recorded that Stop the 70 Tour noted the, quote, necessity for the maintenance of strict discipline within these groups who would be participating in the demonstrations, unquote. This is correct. What we did not want was for people to get overexcited and say, punch a South African cricketer or try to rip their clothes or throw a bomb. We were keen to keep away from violent actions. The main tactic of Stop the 70 Tour and the actions of the majority of those taking part in its demonstrations was to run onto cricket and rugby pitches to disrupt the play. I think I'm right in saying that this was seen as a trespass, and trespass was not at that time a criminal offence. I don't know for sure if getting on a bus and stopping it from moving was a criminal offence. I think it was not. But I did all these things. I sat on a cricket pitch at least once at Lord's and may have attempted something similar at the Oval. I cannot remember what happened to me in terms of the law, though I do remember being carried out by security or police and being kicked by spectators. I also painted slogans on Lord's, on the walls outside along St John's Road. I wrote a message like, "Stop the tour," "Go home," something along those lines. We did not write offensive swearing messages. I did not put Tic Tacs on pitches. I would have considered that as violence. This was not part of Stop the 70 Tours or my direct action group. We disapproved of this sort of action, and this was well known. I do not recall digging up pitches myself. I may have put weed killer on a pitch. All this, though, I would have considered marginal in terms of justification within NVDA, as it was non-harmful of people, so I may have considered it. The test against how we measured our actions was not whether it broke the law, but whether it was consistent with non-violent direct action principles. These were observed by those involved in the campaigns I was involved in. It was understood by those taking part. It was frequently discussed. It was implicitly understood as a core value of those engaging in the campaign against the apartheid South African regime. We did not want our principal message to be confused by adverse publicity about violence. One factor in our thinking was that we wanted to set ourselves apart from the extreme of violence which the apartheid South African regime was showing to its black citizens. Section 8, pavement. I'm asked to summarise my political activities as a member of the Pavement Collective. The Pavement Collective ran from about 1970 for about 20 years, certainly for many, many years. I was one of the main motivators behind setting it up and running it throughout. There were others involved too, though they may not have been involved throughout. Some of the meetings were held at my house. I think I was still living in Fulham, an address on Rumbled Road, at the beginning of Pavement's lifespan. I later moved to an address in Wandsworth. Most meetings were at the People's Aid and Action Centre. Meetings were also held at the home address of one of the others who were active. I was on the Pavement Collective's editorial committee throughout its existence. Its aim was to report on local activity and the actions of local community groups. We sought to publicise the actions of those who defended their local community and to encourage campaigns by local communities on issues like housing, on race, jobs, and similar. We also sought to challenge the council on some of its policies around housing and redevelopment, and this brought us into opposition with developers. We also received support. For example, on the 18th birthday of Pavement, we received letters of support from the likes of Michael Foot MP, the former Labour leader, and Donald Trelford, the editor of The Observer, and the team at the Wandsworth Law Centre. I am asked about its methods. The Pavement Collective was a grassroots community initiative based mainly around a publication, Pavement. This was circulated on the streets, in sympathetic newsagent and outlets, in local housing estates and in community centres. We sold it and it came out about once a month. We also took action, for example, by having a presence outside Wandsworth Town Hall on the evenings of council meetings and similar. The numbers ranged between just a handful and hundreds, depending on what the council was discussing. On one or two occasions, we also intervened in council meetings, either full council meetings or committee meetings. And we did so by standing up in the public gallery and putting questions to the councillors. In one or two cases, we held a demonstration near a councillor's home address. The demonstration would take place on the road outside, and we would not seek to enter their homes, which were all set back from the road. We wrote letters to the local and sometimes national papers with our concerns about issues we thought important. And while there were issues affecting the local community, we also leafleted and organised public meetings, challenging what the council was doing. These meetings were on issues like the development of Battersea Power Station. There were one or two very big meetings on that, and the sale of council houses and the cuts in council services. I am asked if Pavement vetted its members. We did not go through the kind of vetting process a large group would need. The core group was roughly about 10 of us. I wouldn't call them members, and we knew each other. I am asked if we were concerned about infiltration by police or others. And we were concerned in principle, but we were also a small group of people, most of whom had known each other over a long period of time and therefore trusted each other. I believe that Jim Pickford, the undercover officer, had infiltrated Pavement, the editorial committee, by late 1976. I refer to minutes I have of a Pavement editorial committee meeting in November 1976. I would like to know more about what Jim Pickford did within Pavement, and when, and why. It appears that another undercover officer, Michael Scott, was also active in Pavement. I refer to a box file entry of mine, Michael Scott. It's quite Michael Scott, there's a document reference. On that entry, I record that he is connected with Pavement sales as well as Young Libs. This suggests to me that the UCO, Michael Scott, was involved in selling Pavement. I would like to understand why Pavement was seemingly targeted by a number of undercover officers. For example, whether it was used as a way of building undercover officers' credibility within other movements and campaigns. Going forward to section 10, the Battersea Redevelopment Action Group, which is paragraph 96. And I believe you have a photograph reference 051, doc 051, which shows my dad campaigning in Battersea at that time. And if that could be put up, please. That's the one. That was trying to stop a development in Battersea, and there was a demonstration at the development, and that's Ernest standing above a billboard. Okay, thanks very much. Paragraph 96. I was asked to summarise my political activities and as a member of Battersea Redevelopment Action Group. That's BRAG for short. I was active in setting up BRAG in about 1972 and remained active until it was disbanded after many years, at least a decade later. I would not give myself a formal title within BRAG, and others did not have formal positions either. I was one of the group of people taking decisions. That group fluctuated in numbers. The core group was no more than 10 in number, and it was even smaller than that at times. I am asked what BRAG's aims were and whether they were accurately reflected in a report I have been shown dated 23rd of December 1974. The report I am referred to does not accurately reflect BRAG's aims. Paragraph 102, the BRAG campaign was much broader than this. Our main activity revolved around what was happening at Battersea Power Station. The council and private developers wanted to transform it into a luxury housing. If the power station was to be developed, BRAG wanted there to be affordable council housing and community projects and facilities. This was BRAG's overarching objective. We also campaigned against the council selling off other property, selling off council houses in the area. These were the sorts of general concerns we had and campaigned on. I am asked if BRAG subscribed to a particular political doctrine. There was no party political doctrine. The politics we espoused were based on the principle that council developments and initiatives should be public and for the community, rather than private and for commercial interests. It was a typical community project campaign founded on localism. I am asked what methods BRAG used to advance its aims. We were committed to conventional campaigning methods and, of course, the principle of non-violence. Within that framework, we considered any appropriate action, leafleting an area, organising public meetings in local areas, door knocking on certain issues. In a wider sense, we would go to council meetings and put questions to the council, intervening from the public gallery if that's what was needed to ensure our questions were asked and the answers were given. And we were also active in public inquiries and planning applications around the development of Battersea Power Station and the area around it, particularly along the riverfront. I am asked if Bragg vetted its members. We felt that we did not need to vet anyone. But suspicions concerning one person did lead us to a confrontation at one of our committee meetings, and that person was excluded. I recall it was quite an unsettling incident. Our concern may have been whether that person was an undercover police officer, and I would like to know from this inquiry whether that person was an undercover police officer or similar. More broadly, I would like answers from this inquiry on the following issues. I would like to know if any other undercover police officer beyond those already disclosed to me was involved in any of the campaigns I have been involved in. I would like to know what information UCOs obtained from those campaigns and what was done with that information. I would also like to know whether, and if so how, any UCOs sought to disrupt the campaigns. Did any UCOs seek to have a genuine campaigner ejected from the campaign, for example? I'm concerned about UCOs interfering in the organising of political groups, such as the ones I was involved in. And it is worth bearing in mind that these were often small groups run by their members, all of whom were volunteers, and I would be very concerned to learn if UCOs were participating in the political decision-making of those groups. I hope that the inquiry will address these issues. Going to go forward to paragraph 123. I'm asked how frequently I experienced violence during my time at Bragg or any other group. And going forward again to 127. There was police violence against the Committee of 100. When there were demonstrations at the American Embassy or a nuclear base, we were knocked about by the police when we were arrested or even moved from the base. Sometimes the physicality was quite severe. They dragged people by the hair, accidentally, in quotes, stamping on people. So they dragged people by the hair and, in quotes, accidentally, unquote, stamping on people when trying to move them. I was occasionally stamped on. I witnessed others being stamped on or pulled by their hair. All of our actions were passive forms of civil disobedience, such as lying in the road. As for Stop the 70 tour and the Direct Action Group, I also experienced or witnessed violence. When I was involved in a demonstration at the centre of Lord's Cricket Ground, I remember the stewards, or even members of the public, roughed us up unnecessarily when dragging us off the pitch. They also surreptitiously punched us. I remember being dragged past the seated spectators and the crowd kicking me on the way, causing me bruising. I witnessed similar things happening to other campaigners. During the anti-nuclear campaign in the late 1960s onwards, we occupied Grosvenor Square and Trafalgar Square, Whitehall and other sites in central London on various occasions. These were mass demonstrations, peaceful sit-downs, with some campaigners linking arms and others using padlocks and chains to attach themselves to each other. It was clear to me that the police, frustrated by the task of having to remove us, lost control and used unnecessary force against us. They punched, often surreptitiously, dragged people violently out of the way, stamped on people who were in the way of another person they sought to remove. And this happened to me on several occasions. I was pretty violently removed from peaceful protests, including being stamped on. Similar things happened at weapons bases. I recall being stamped on, dragged across fields, generally knocked about by the police who were removing me. It was unnecessary violence because I was passive and peaceful. I do not recall the police ever taking action against those responsible for violence against me or against other campaigners. I don't recall them taking action against stewards or members of the public or fellow police officers. I would like to know if undercover officers ever experienced such violence while posing as activists, whether they witnessed violence against other genuine activists, whether there was any incentive to record or report this, and whether they ever did so, and whether they could have given, or indeed ever did give, evidence against those responsible for violence against activists. I am sure that undercover officers could have done all of these things. Looking back on the basis of what we know now, it seems logical to conclude that there was a policy of allowing aggressive and violent behaviour towards activists to go unchecked. Undercover officers would have known what we were experiencing and probably reported it to their handlers, yet it was still being allowed to happen. Just going forward again a bit to paragraph 139, section 12, Jim Pickford, and a report on the Wandsworth branch of the Anarchist Workers Association. I am asked about this group in the light of this report of a meeting of that association on the 8th of January 1976. The only comment I can make is that it appears that in November 1976 he used his role in Pavement and in the circulation of this publication as a bridge to being involved in and perhaps gaining credibility within the AWA, that's the Anarchist Workers Association. I do not know if this, my own understanding of what may have happened, accords with what the inquiry knows from its own records and investigations. Section 13, personal information on me obtained by UCOs. I am asked about two special branch reports dated 1976 and containing very personal information about the birth of one of my children and a health condition of mine. The first thing to say is that the information in the first report about the birth of my son is accurate. I did have a health problem of the sort described in the second report at the time reported. However, I cannot be confident that it was as serious as is reported, and the name of the hospital treating me may be wrong too. I am asked if this information was widely known. The information about the birth of my son was, of course, known to close friends and family, but it was not reported formally, publicly, anywhere, or of wider interest. And similarly, my health condition would have been known among my friends and family, and there would have been some concern, but it was not more widely known than this, or of wider interest. I am asked my reaction on learning that information of this nature was reported on by undercover officers. This has surprised me. I find it sinister and invasive, and it troubles me greatly to learn of it, even after all this time. It is not a surprise to me that the police were monitoring some of the activities I was involved in, but it is a surprise to me that they were taking a note of the birth of my son and of my health. Those things were unconnected with political activity and were of a particularly personal nature. Although I am not asked this, I am particularly surprised that these records have been kept for over 40 years. This is also quite sinister. It is not as if I was an international criminal. It is reminiscent of the behaviour of authoritarian states. It has no legitimate justification. And it reinforces me in my view that I would like to have from the police, through the inquiry, all information that all UCOs and Special Branch have recorded and stored about me at any point. I would also like to know which officers were monitoring me at any time in my life and what they did in order to gain this information and what use they put this information to. So section 15 is events at a hotel in Richmond. There are two photographs that relate to this that I think you have there, the UCP references ending 072. There's two photographs, you could show them in turn. I think they're just photos 2 and 3 in the list. I can carry on reading if, oh no, here we go. So that is Ernest with the camera, and the following one, Ernest with the notebook. Okay, thank you very much. So paragraph 153. I'm asked to set out a factual account of my involvement at this demonstration, including planning in advance, my arrest and prosecution in the light of a number of reports. It was a demonstration at a Richmond hotel on the occasion of the British Lions rugby team departure to the airport for their tour of apartheid South Africa. At the time of the incident, I understand that the hotel was called the Star and Garter. I do not recall this incident or what followed very well, but I have had my memory refreshed by reading the documents provided by the inquiry. The following broad points which come out of the report and documents do seem broadly accurate. I was a main organiser of the demonstration, and we, those who were going to be involved in it, met on the day of the demonstration at my home before the demonstration to plan and prepare for the action. I see that Michael Scott, a UCO, attended the planning meeting for the demonstration, having supposedly been told of it by Peter Hain's mother on the phone. This sounds unusual and out of the ordinary. She, Ad, is likely to have told someone she did not, she, Ad, is unlikely to have told someone she did not know about something so delicate on the phone. I knew her and what she was like. She would have been very careful about giving out this sort of information, particularly given her experience of South Africa and surveillance. It is therefore possible that Michael Scott may have got involved in the planning for the demonstration in another way, other than the one described in the report. In attending the meeting before the demonstration, the UCO may have added his voice to the decision to take direct action before the action took place. Our plan was to blockade the UK rugby team's coach at the Star and Garter Hotel in the hope that the players would miss their flight to apartheid South Africa for the forthcoming tour there. These plans included ordering skips to the hotel and cars being parked in the way of the coach and protesters getting in the way of the vehicle, all in order to block or delay the coach's departure from the hotel to the airport. I cannot now remember precisely what I did or where or the order of events, but I do remember being arrested outside the hotel. Before that, I may have parked my car, a maroon Renault 4 with a roof rack, in the car park at the entrance to Nightingale Lane to cause a blockage there. I may then have sat down to block the coach, possibly in the car park, as the coach left the car park. I cannot remember what others did. Some may only have taken action in the car park. And I have found and now produce 6 photographs which appear to date from the incident. 2 of those photographs are the ones we have just seen. I can be seen in those photos. Going forward to paragraph 167, I have now found a letter in my paperwork from PT to me dated 14th of June 1972. Attached to it is what PT describes as my rather uninformative account of the events at the hotel. He signs the letter off by wishing me best of luck with the trial, and I produce this letter and account. He describes the incident, his role in it, and he also describes what Mike Scott did. Paragraph 171, a lot of this tallies with my own independent recollection of events. And going forward to 173, I was arrested and prosecuted. It is almost certain, confirmed by the intelligence reports, that there was discussion between the activists who were defendants about our case, preparation for a trial, including possible defences to the criminal charges. It would not have been common for defendants to have shared with other activists who were not defendants information about, say, their discussions between themselves about their case. Nor would it be common to share with those others the views of their lawyer or discussions held with the lawyers by their defendants. There would only be some sharing of information with non-defendants if there was a particular reason for doing so, for example, to try to find witnesses or to get wider support for the case. One possible defence to the charges we faced was that relevant events took place in the car park and that this was not part of the highway, the relevant road being Nightingale Lane. It seems from the intelligence reports I've been referred to that Michael Scott or those who recorded information he provided could have given relevant evidence, some helpful to the defence, in the criminal proceedings. And I note in particular these references in the intelligence reports, which appear to show that Michael Scott and those receiving the reports knew that most of those arrested were not guilty. Michael Scott could have given evidence about the location of the demonstration, about whether it took place in the car park or in the road or the highway or beyond the car park. The police UCO records contain a report dated 16th of the 5th, 1972. And the report writer does not suggest that this is in any way a false defence, at least for the majority of the defendants. The defence is consistent with the account of events at the hotel provided by HN 298 earlier in his report. There is no attempt by Special Branch to inform anyone involved in our prosecution that any of us may have been innocent, though I note that the Metropolitan Police report was sent to the Solicitor's Department and to Special Branch. Evidence from Michael Scott supportive of the defendant's account and contradicting uniformed police officers' evidence would, coming from a serving police officer, have been more credible than had it come just from protesters. I normally plead not guilty in protest-related prosecutions. I'm going forward to paragraph 189. But the approach I took to my defence would have been different had I known that Michael Scott was an undercover officer. It would have been different had I been aware of the contents of the intelligence reports now provided to me by the inquiry. The account of PT would have been much more significant had I known that the Mike Scott he referred to was an undercover police officer. I understand the offence of obstruction of the highway, contrary to section 121 of the Highways Act, required the prosecution to prove that there was an obstruction of the highway and that it was not reasonable. The actions and evidence of the UCO Michael Scott would have been relevant to both of these issues and whether I had defences based on them. I am asked if I recall Michael Scott, the undercover police officer apparently involved in the protest and court proceedings. And I do not recall a Michael Scott being involved in the protest and court case. I do not remember him at all on the information provided to me by the inquiry. I would be assisted if I were to be shown contemporaneous photos of him and some other description of him and his appearance and other interactions I may have had with him. I note, however, that his name and details appear in my box file of contacts from that time. And I note that the first address for him on these box files is the one he gave to the court, 16 Weatherby Gardens, SW5. I'm asked if I am surprised to learn that one of the 14 people arrested that day was an undercover police officer. And I am surprised that the police used its resources to place an undercover officer in a peaceful demonstration, part of a wider campaign to contribute to the isolation and collapse of the apartheid South African regime. I am asked about my reaction to learning that Michael Scott was an undercover police officer. I was very concerned to learn many decades later that an undercover officer was involved in the demonstration, was arrested with me, and stood in court with me and others. I am concerned that he did this in his false identity, that he may have given the court a false name, and that he may have given evidence in that false name. Furthermore, the undercover officer was convicted and sentenced under that false name. And I would like to know whether that individual accepted that he was a criminal when living later under his true identity, whether he declared this conviction when asked about his previous criminal convictions. Paragraph 200. I am concerned that this officer appears to have been involved in discussions with the group of activists and defendants about how to deal with the prosecution. Michael Scott may also have been privy, either indirectly from what people told him, or directly by attending meetings, to private legal discussions between activists and defendants and their lawyer. And he may even have influenced or had the opportunity to influence those discussions. These discussions may have been about fundamental questions, the evidence, the prosecutions and ours, and what defences we might have, and whether to plead guilty or not guilty. and he may have reported directly or indirectly to the prosecution what was discussed, supposedly confidentially, between the activists and or their lawyer. And I note that there is a reference to the police being conscious of the, quote, potential of embarrassment to police, unquote, if Michael Scott were to have been involved in the protest and in the criminal prosecution, in his cover name, and then for it later to come out that he was a UCO. This seems to highlight a failure to have procedures and criteria for the oversight of UCOs in this situation. There is no mention in the note of more important concerns, that the other defendants in the criminal proceedings should have a fair trial, that innocent demonstrators should not be convicted of offences that they have not committed. The only concerns expressed seem to be for institutional damage to the police, and the failure to view activists as individuals with their own legitimate rights and interests, and the decision to place those second to the unfettered gathering of information on them may be a precursor to some of the more gross abuses of activists that I know happened in later periods of undercover policing of campaigners. Going forward to paragraph 209, section 19. I am asked if there is anything else of assistance to the work of the inquiry that I want to add. We were aware that there must have been some plant and authority-placed figure within Stop the 70 Tour. I was pretty sure at the time that I personally was of interest to the authorities. This is because before the incidents and campaigns I am now asked about, I had been involved in more direct action as part of other campaigns. I was one of the Committee of 100, which campaigned against nuclear weapons and took action at military bases and elsewhere. This was in the 1960s. And indeed, before that, I was involved in CND2. I took part in and was very involved in publicising the first Aldermaston marches, popular marches that were from 1958 onwards against nuclear weapons, particularly those stored at AWE Aldermaston military base. It seems to me that my political activities before 1968 and the intelligence held on me by the police during this period are relevant to this inquiry. For example, I refer to these comments in page 1 of the report surrounding my involvement with other protesters in the hotel protest in May 1972. The group of protesters is referred to as a, quote, group of anarchist-orientated extremists under the control of Ernest Rodker, quote, unquote. And it then describes me as follows, quote, this man has been a thorn in the flesh for several years now, having had no fewer than 14 court appearances prior to 1963 for offences involving public disorder. He was considered to be a menace at the time of the protest demonstrations taking place in this country concerning the Springboks rugby tour in 1969 and the Stop the 70s tour in 1970, unquote. Now, I do not accept this characterization of me, the other protesters, or our actions. For example, from memory, my arrests were for acts of NVDA and civil disobedience and were against nuclear weapons and the apartheid South African regime. The intemperate language in this report suggests a lack of judgment on the part of the police and a lack of respect for the right of peaceful protest. But the point I make here is that Special Branch and the undercover police they work with had access to much more material and intelligence, albeit incorrect and dating back before 1968, than has been disclosed to me. And this appears to have informed their decisions on how I and the campaigns I was involved in should be monitored and policed from 1968. And I wish to see all this material and intelligence. I challenge the legitimacy of the police spying on me at all, and to such an extent, and then retaining these records for such a long period of time. I would be very interested to learn what else the UK authorities may have recorded about me and my activities. Paragraph 218. I am aware from what I have seen in the public domain that Special Branch collated more information on me and the campaigns I was active in beyond what has been disclosed to me by the inquiry. Paragraph 222. I would like this information not only to understand the extent of state surveillance on me, but also more practically, in order for me to be in a position to provide further and fuller comments of assistance to the inquiry. For example, I have been made aware of the following police records, not provided to me by the inquiry, but obtained by my solicitors from materials in the public domain. There is a Metropolitan Police Special Branch report dated 7th of April 1970. It is supposedly the, quote, first of a series of fortnightly reports and comment regarding the proposed actions of persons and organisations opposed to the cricket tour due to take place from the 2nd of June to 28th of August 1970. And its reference to me appears at paragraph 12 as follows. Some of the leading personalities in the Stop the 70 tour and allied organisations are ... Ernest Rodker, Stop the 70 tour, ex-Committee of 100. Now this, the reference to Committee of 100, suggests that Special Branch in 1970 were aware of and had a record of my time in the Committee of 100. And this tallies with what I knew when I was active in the committee. When I and others were taken to Bow Street Magistrates Court, found guilty and sentenced, I recall that the prosecution produced evidence that the police had observers and infiltrators at the Committee of 100 meetings recording what was said. And they were therefore able to prove that we were at those meetings and the part played by the defendants in those discussions. That was part of the prosecution evidence at the trial. Paragraph 228. Secondly, there is a 10th of April 1970 Metropolitan Police Special Branch report, which includes at paragraph 4 this reference to me in the context of the second conference of the Stop the 70 tour and a discussion about the use of mirrors to shine into players' faces during sports matches. Ernest Rodker, the chairman of that meeting, was overheard to remark to those present that the mirrors had sharp edges, and in order to obviate the possibility of those found in possession of them at cricket matches being charged with possession of offensive weapons, the edges should be bound with adhesive tape. Now, this is the sort of responsible thing I would have done to reduce the risk that by using mirrors at Stop the 70 tour demonstrations, we might inadvertently cause damage and run the risk of arrest for a more serious offence. I do not understand why this report, which names me and casts me in a good light, has not been disclosed to me by the inquiry. And finally, paragraph 2 through 1. This makes me question whether the police have provided all information to the inquiry and or whether the inquiry has disclosed to me all relevant materials. I feel I should be entitled to see all Special Branch and undercover officer material and intelligence on me. I would like this for its own sake, so I can contribute fully to the inquiry, to have some reassurance that the inquiry is canvassing fully the views of activists such as me who have been victims of undercover policing, and to have some level of reassurance that the inquiry's examination of the evidence and its conclusions can attract the confidence of the victims of the undercover policing. I'll finish there. Thank you very much.
Thank you very much for bringing your father's words to life. May I raise two things with you? First of all, your father can be reassured that the inquiry has done its best to provide to him all of the documents that it has in which he is mentioned or which refer to him. That does not include all of Special Branch reports such as there may be upon him, because I am only investigating one small unit within Special Branch, the Special Demonstration Squad, and that may well be why he has been able to obtain Special Branch documents, but the reason is they weren't produced by the Special Demonstration Squad. The second thing is, this is a question to you, to which I suspect I know the answer. If I were to conclude that your father's conviction arising out of the Star and Garter demonstration was at least arguably a miscarriage of justice, and I therefore am required by my terms of reference to refer it to a panel which will consider what to do, Am I right to assume that you and your father would like that to occur promptly rather than to wait until the end of the inquiry?
I think that would be his position. I mean, the reason I'm speaking is because he's unwell, is elderly and in ill health, and it would certainly ease his mind to know that things were proceeding as promptly as possible.
Subject to something unforeseen occurring, you may reassure him that I will do my best to do that.
Thank you, Sir John.
Thank you.
I assume I just turn off my channel, as it were, now, or it will be turned off for me.
Yeah, we're going Mr. Fernandez is going formally to close the proceedings, and you will then, as you rightly observe, be turned off.
Okay, thank you.
Thank you, everyone. The hearings have now finished for the day. We shall resume at 10 a.m. tomorrow.